Matt Bishop.
Thank you, Madam Deputy Speaker. When I was serving in the police force, my work often ended when we put perpetrators behind bars, or sometimes when I stood in the court to give evidence. But for the victims, their ordeal sadly doesn't end there. Many reached out to me long after my role was done to tell me that they still felt unheard, unprotected, and that justice for them was never truly served. And too many survivors live in fear, which is why I welcome the provisions in this bill. Victims checking over their shoulders, altering their routines, wondering when the person who hurt them might walk free and attack them again, and that's no way for anybody to live in society. It's precisely why I welcome the provisions in the bill, such as expanding the victim contact scheme, which will give victims vital reassurances, protecting them from being blindsided by their offender's release and helping them reclaim a sense of safety. I'm particularly pleased about new clause 14, which many members have spoken so passionately about today, and pleased to see the presumption of parental access suspended for parents who commit crimes against children. Because one child lost due to a criminal parent being granted unsupervised contact is one child too many. No one should ever have to risk their child's safety because of a system that puts rights before reasons. And ordering offenders to attend their sentences is another critical step, both in that process and the next process as part of the bill. Victims deserve the chance to look those responsible in the eye, to be heard and to begin healing. And perpetrators must face the full weight and impact of their crimes, no more hiding from the consequences of what they've done. And it's on this point that I must highlight the work of the Justice for Victims group. An organisation of families who I've had the privilege to meet on several occasions, who have turned their pain into purpose. Sasha Brett was 16 when she was raped and stabbed more than 100 times by her killer. Tony Hudgell lost his lower legs as a result of child cruelty by his own parents. Sarah Everard was abducted whilst walking home by a serving police officer, raped, murdered, and her body was disposed of. At just 4 years old, Violet Grace Ewins was killed by a dangerous driver in a stolen car driving 80 miles an hour in a 30 mile an hour zone, the perpetrators spent barely more time in prison than Violet was alive. Last but not least of this group, Jan Mustafa was killed by a serial sex offender who stored her body in a freezer alongside another murder victim, Henriette. The families of these victims are just a few of many who have been let down by the justice system and its treatment of victims in one way or another over time. One victim told me that their victim impact statement was so heavily edited by defence lawyers that they barely recognised their own words. How can anyone find closure when their voice is silenced in that way? And it's not right. It's why I'm pleased I've spoken to my friend, the Minister, several times in depth to talk about this, and why I welcome the outcomes that she's brought forward. And it's why I want to see, and have campaigned so much to see, real reform of victim personal impact statements. No family should ever have to water down their grief or pain just to spare the feelings of the person who's caused it. And victims deserve to be heard in their own words, honestly and fully. Offenders must also be made to hear every word, to confront the true devastation that they've caused. The principle ties directly into the provisions of the bill. Yes, offenders should be compelled to attend their sentencing, but they should also be compelled to listen to how their crimes have impacted victims and their families. There should be no place to hide for perpetrators and no reasons for victims to edit or soften their voices to fit the comfort of those who harmed them. Justice for Victims is also calling for clarity on terminology. Life sentences don't mean life, so we should stop pretending that they do. Justice for Victims are also right to call for a clarity of life sentence, and it should mean that life is behind bars for life. Yes, we have whole life sentences, but it doesn't do them any harm or favours when life sentences, without being a whole life sentence, is not equivalent to 12 years, I think. The public deserve honesty and victims deserve truth. Additionally, there must be changes to the time limit set on victims' families to be able to appeal offenders' sentences. Katie, who's Sasha's sister, said that currently victims and families only have 28 days to appeal unduly lenient sentences, normally at a time when they are grieving and traumatised. But criminals are allowed to appeal after this time in exceptional circumstances. But why don't victims and their families get the same rights? And that question cuts to the heart of this debate. Victims and families deserve fairness and they deserve to be heard. These are not radical reforms. They're small, practical, compassionate steps that would make a profound difference to people's lives. So in the interest of time, Madam Deputy Speaker, I wholeheartedly support this bill and the progress it represents, but I do urge the Government to go even further to deliver real justice for victims and survivors and to ensure that no one who has already suffered once is ever failed by this system ever again.